We're on the last session of today, second day of the workshop, and there are no new people around the table, so we're going to skip that round of introduction, and we're going to let Eden just say a couple of words about the introduction. And
hi everyone. I'm Eden Lapidor. I'm an SGD candidate at Georgetown University. I'm in my third year, and I research IHL in NIAC, trying to find the balance between humanitarian consideration and military necessity. And the paper that I'm presenting here is actually part of a chapter under my dissertation. It's titled On Discontinuous NIAC and the Proper Legal Regime. And so that's the paper that you were distributed. And my goal, in essence, is to turn it into a standalone paper and to try and make it publishable. So I would really appreciate any thoughts, ideas, comments that you might have. And before I'll start, I was just going to say thank you, Ido, for chairing this panel and for this wonderful conference. And really happy to be here and present. So, as you may all know, NIAC as opposed to IAC, NIAC as non-international armed conflict, as opposed to IAC international armed conflict, is between a state and a non-state armed groups, or between two or more non-state armed groups. What makes it non-international armed conflict is not the question whether or not the conflict is cross-border one, but the characters that are part of this conflict, the part of non-state actors as a member of this conflict. Often in NIAC, non-state armed groups disregard IHL, they blend in the civilian population, either operating within it or do not wear any uniform, or they're using the civilian population as a target to their need. So for asserting the existence of NIAC, the level of violence also needs to be different than the one. So another characteristic of NIAC, that its threshold is different than the one of IAC, right? If an IAC can be started from a border incident, in NIAC it's different, and we've heard it today and this morning. Another characteristic is NIACs are very hard to determine when they end. This is because conflict has different, this is because the law of IHL does not have specific rules to detect when NIAC ends. So neither Additional Protocol 3, which is the mini convention of NIAC, nor AP2 gives us exactly wording, so to speak, to how to detect an end of conflict. And this question is particularly important when it comes to discontinuous NIACs. So what are we talking about when we're talking about discontinuous NIACs? So for the sake of this question, in the paper I present this hypothetical, where we have state S, that is fighting a non-organized armed group N for many, many years. And during that time, there are off and on periods where active hostilities occur and sometimes where there's no hostilities at all. And as I've mentioned, is a non-state organized armed group, which makes this conflict to be a NIAC. In addition, N is operating from an adjacent territory to S, where S do not have any effective control. Okay, so it is important for our conversation afterwards. Examples for discontinuous NIACs are the conflict in Colombia, which is one of the longest in history for over 50 years. Also in Sri Lanka, the conflict between Israel and Hamas in the Gaza Strip, as well as the US and ISIS, or the US and Al-Qaeda. All kind of conflicts kind of like have a long period of time of conflict where had on and off periods of them. The external conflict that I'm really interested in are the cross-border ones, where the state does not have effective control over the territory that the conflict is taking place. So what I really envision is Israel versus Hamas and the US, Al-Qaeda, ISIS kind of a situation. And these kind of conflicts bring us to this question, this unique question, that is, which legal regime should govern the laws when no active hostility takes place, although there is on occasion some level of hostility. And Why is this an important question? Because it happens. We have those times when there aren't many, rockets firing from one side to another, but still some riots, maybe, if you all remember, maybe the 2018 border incident between Israel and Hamas. So that's kind of like what resonates this whole conversation. So the legal option to consider when discussing this question are the following. So the first one is a ceasefire agreement in NIAC should be viewed as the end of the conflict. And in other words, it means that from this moment on, from the start of this ceasefire agreement, there is the conclusion of IHL, right? Because IHL only applies when there's a conflict. So if you have this agreement, maybe the conflict ends. The second option is to consider is the applicability of IHL throughout the entire conflict. Okay, so even during the laws, IHL is the regulatory regime as a sole regime. The other option is IHRL, International Human Rights Law, to govern during those laws. And the last option is a dual application of IHL and IHRL. Understanding which legal paradigm is the regulatory regime during the law can have tremendous impact on civilian protection and the right of the armed member to the fighting parties. So while the question of when NIAC begins, and to some extent to determine when it ends, has been kind of discussed by scholars, the question about discontinuous conflict and how it should be regulated has been quite silent thus far. So, and despite the wide acceptance that IHRL is also applicable during conflict, the question of how exactly IHL and IHRL interact still remains a question. And this paper tries to provide another perspective of this sort of debate, focusing on discontinuous NIAC. So let's start with our first option and see the ceasefire in NIAC as the end of the conflict. So as I've mentioned before, IHL only applies so long as an armed conflict exists. For this reason, it is important to explore whether the ceasefire agreement in NIAC and provides this end of the conflict, and therefore when laws occur, so when those small incident happens, IHL would not be the regulatory regime. Now, the Geneva Convention and the protocol addition to them do not provide an answer to the question, when does NIAC end, and neither the original commentaries. The 2016 commentary of the ICRC to the first Geneva Convention provides some factors to consider in determining whether NIAC has come to an end. So according to the commentary, NIAC can end when one of the parties ceases to exist, okay? Due to a complete military defeat, for example, and in this case, subsequent acts of violence or isolated or sporadic acts by the dissolved member of those groups would not classify it as NIAC. A lesser degree of defeat when the group is suffering from disarray and can still regroup would not end IHL regime over this conflict, so to speak. According to the commentary, NIAC do not end when the level of hostility between the parties fall below the threshold of the NIAC threshold as the Tajik gives us. And this is because the ICRC, in their idea to it, tried to eradicate the idea of this revolving door between the application of IHL and IHRL, on and off switch. So I've mentioned the Tajik case, but in Tajik, it mentioned that NIAC continues beyond the cessation of hostilities until a general conclusion of peace is reached. So if taking this literally, at first instance, it would mean that, okay, once a peace agreement has been made between the parties, it necessarily negates the applicability of IHL to this conflict. However, as we all know, sometimes hostilities continues after the conclusion of these ceasefire agreements or unilateral declaration of ceasefire. Therefore, relying solely on the existence of such agreements to determine whether or not NIAC had ended would be a mistake, and therefore I don't think that we should look at them as the end to the NIAC. There are many reasons for lull to occur in prolonged NIAC, such as fluctuation level of operational capacity due to lack of sufficient munition, the death of the group leader, commander structure change. So all of those different scenarios make it difficult to exactly pinpoint when NIAC ends, leading us to question again, so what happens during those lulls? So one option to explore would be the application of IHL for those laws. So while IHL applies when armed conflict exists, it is presumed that IHL continues to apply. With that, the traditional view of some states like the US and Israel is that as a matter of less necessarily, IHL replace IHRL during armed conflict. So that's why only IHL is applicable to those laws. The European Court of Human Rights in the Georgia versus Russia second case commented on IAC, and it says that when parties to the conflict are fighting to create over a territory and there's no overall control in that territory, the jurisdiction of the court does not exist. So thinking of that would provide us kind of an easy solution to the question, what kind of legal regime exists during those laws, especially when there is no control over the territory. And it would say, okay, so IHL, that's a legal regime. But it's not as easy in that complex, that easy solution when discussing NIAC. They were talking about IAC in that case. Also, the problem with assuming IHL to every single situation in the laws, it is justified the use of force at its most harmful or most extensive mean. So it means that non-member states of those armed groups could be targeted at first instance, instead as IHRL demands to be and try to arrest and then to attack, and then to target or to use force only as when there's an imminent threat to an individual. It's not on the screen, of course. It also allows harsher method to be used, so live munition and as opposed to riot dispersals such as tear gas or rubber bullets. And it also may lead to the abuse of power under the law, right? Because if we have this ability to use force at its most extreme way, why not use it if we have this justification? So one way to solve this option would be to rely on what Ziv Borel had beautifully expressed, and would be the adaptation approach. According to this approach, we can borrow from one branch of IHL to accommodate different situations that do not necessarily follow under this branch of the law. In laws, for example, we can borrow from this from occupation law, and in that way to create this law enforcement mechanism under IHL. So in that kind of situation, it would provide us a way to give greater protection to civilians under IHL that must not necessarily exist under NIAC IHL. It would ensure that the state's interaction with enemy civilian would be, although IHL still exists, it's still more limited in nature. And it provides also some safeguards, such as protection to property of the civilian population and the way that they are treated under the penal system. And again, it's greater than what we have under NIAC's IHL. The adaptation approach also prevents this revolving door that we want to avoid between IHL and IHRL. But as I mentioned in the article, I'm not quite certain that this adaptation approach is how we should apply the law, or not should, whether or not it's lex late or not lex orenda. And I do think that there is some issues with it. So I'm not quite sure that we can use this as a way to solve this issue. Another option would to use IHRL as a matter of policy. And it's something that the US really loves to do. It says that it's still in an ongoing armed conflict. It uses IHL, but it limits its power and the way that it uses it in accordance to IHRL. And they're doing it in the whole, I'm sorry, I'm losing words, in their targeted missions. But I don't think it's a great opportunity to use it, because using policy as first off would not prevent next administration from going back to only applying IHL, even though we did see that that the Trump administration did reserve some of the same policies that Obama. And of course, because Bush started this whole global war on terror, he's the blame for everything. And so beside that, it depends on this like good grace of the administration. It also prevent IHL to prevent as a legal matter, because we're only relying on what the states think it should do, but not as a legal obligation, and therefore we don't have any opinion use. So maybe not use IHL during laws. The next option would to implement IHRL during those laws. So applying IHRL regime during laws makes a lot of sense, since the overall assumption of IHRL is that we're returning to regular life. It's like almost peaceful. And when conflicts occur among civilian population, as it is the case in NIAC, it is all the more reason to limit and restrain as much as possible the immense force that the state can use against either members of the armed groups or civilians in that matter. So it would provide greater protection to the civilian than IHL regime would do. IHRL, you need to remember, do not allow collateral damage as opposed to IHL. So again, greater civilian protection. It also demanded an attempt to arrest would be made prior to the use of force, unless such a option is not feasible. So while it restrained the use of force, it might be suitable for internal NIAC. I'm not quite sure it would be also possible to implement it in external NIAC when the state do not have effective control to use all of those tools, because it doesn't have the same ability to use this tool. So I'm doubtful for this option. And we also need to remember that there is this question whether or not IHRL applies extraterritorially. So although a lot of states do believe that, we still have the question of the scope of it. So I'm not quite sure that we want to do it as a matter of legal term. But that leads me to the next option, which is the dual application of IHL and IHRL. So understanding the limitation of the previous suggestion, another approach would to view IHRL and IHL applied in a hybrid manner. Under this approach, both disciplines can be utilized to fertilize and balance the state's ability to conduct operation and its obligation to protect civilian life well-being. The starting point of this approach is the understanding that IHRL and IHL are not mutually exclusive, but rather influencing one another. It derives from Article 3C to the Vienna 3C, to the Vienna Convention, that says that any relevant rule of international law applicable in relation between the parties should be used. So this allows us to see the international legal system as a coherent and a normative system that do not conflict between one set of rules to another. It allows IHL to be interpreted in light of IHRL and vice versa. However, there are situations when there are clashes between maybe rights or obligation under one regime, and therefore we shouldn't overlook those obligations just because we're trying to make this hybrid situation. So what I am trying and suggesting in the paper is the approach of a situation-based harmonization approach. Under this approach, in a situation that resembled peacetime, IHL would be the regulatory regime. However, the option to default to IHL if situation escalates, if the violence gets a bit too much. What? Okay. We still all those technical difficulties. We still have this option to default to IHL, so it gives the state greater sense of serving its interest. Under this suggested situation-based harmonization approach, it would make much sense to regulate protests, as I mentioned in the hypothesis, under IHRL, while remembering still that if the conflict escalates, so if, let's say, members of the armed group are there and are utilizing this whole situation and throwing rockets or bullets against the forces of the state, it would allow the forces of that state to use IHL as a response, use force as the first instant. Okay. Sorry. I lost numbers. It also provides us with utilizing IHR well, even though the state do not have effective control. It prevents this revolving door between the application of IHRL and IHL because it maintains this idea that they both exist. And it do not disregard the application of IHL as if we only want IHRL to regulate the laws. Again, it's a legal solution also and not a policy because we're going to look at it as a matter of law. So as your question before, it's a lex ferenda and not lex lata, obviously. And it also better suits the nature of this conflict, right? Because it understands the complexity that we're dealing with. So I'm aware that it's not a perfect solution and there are going to be a lot of pushbacks. One of them, it means that it's going to put the situation of pick and choose between the two legal regimes, right? That I can always do whatever I want as a state, but it still provides a leeway in the way the situation is being thought of, where it is closer to peace or to active hostilities. And it would give us a better sense of understanding how to act and how to react. Another pushback would be that, soldiers will always be soldiers. They're always going to see conflicts, never like, even if it's riots, as tainted in the whole conflict kind of glasses, and therefore they're always going to implement IHL instead of lesser means that IHRL demands. But I think we can teach them, so it's not that big of a deal. And the other problem, which I think is the most dire one in NIAC, is that it's going to be hard to differentiate between who's a civilian and who's not, due to the nature of this conflict, and I don't have an answer to that. So to sum everything up, so despite the potential pushback that I mentioned, and although that I don't provide a rule of thumb to every situation that might occur in NIAC's law, the situation-based harmonization approach presents some way to conceptualize in legal terms the unique situation that occur in discontinuous NIACs. I argue that the situation-based harmonization approach provides a better solution in the complex reality. It's a legal solution and not a policy one. And it better protects the civilians, because under this approach, the use of lethal force would be only lawful if it's immediate threat posed on the individual in question. Otherwise, a less harmful means would be used. It also limits the ability of the states to lawfully conduct targeted killing during laws. And I'm saying it especially when thinking about Israel and the fact that it continued to assert that it's an ongoing armed conflict with Hamas, and therefore at any situation, at any point, it can just target a potential member of Hamas. And as a direct effect, it would limit the casualties, the civilian casualties to those operations. So it would lower the risk of the civilians. Yes. Sorry for a lot of mumbling during this presentation. I'm open to every question, criticism, comment that you may have. And then I presented it in person and not Zoom, so it's also
Thank you, Ellen.
You.
So I'm gonna respond to that from different perspectives and different aspects. Some of them, as we've done already in this workshop, might contradict myself here and there. Some of them will contradict you as well, but I don't think I need to be coherent here. So generally, which is part of what we talked earlier and what you said at the beginning of your presentation, this article is basically a chapter that is trying to be condensed, edited, I find an identity basically to be published. And I think for some extent, it actually looks like a chapter of a PhD dissertation that holds stuff that should be put in a PhD dissertation. Although it's, I have to say, and some of you around here that everyone knows that at least it's 30 page long and not 70 page long when you're trying to find your way. But still, I think there are parts that might, for the publication, need to find yourself either reduced or removed. So you start in the whole notion of how do you classify a conflict and the beginning of where a NIAC, and then the problem is the ending of an international conflict, and you provide some presentation of the options, and then you slowly push it towards the LUL, right? This is where you're trying to push. This is what you want to talk about. So there's, in the paper at least, there's a big introduction that leads you basically to the fact that you don't want to talk about the end of the conflict. You don't want to talk about the beginning of the definition of the conflict. You want to talk about that undefined situation where the conflict hasn't ended yet, but you don't know necessarily what regime. So I would go faster to that, and then you're trying to find some solution to the LUL under IHL, HRL, a combination thereof, of etc. Now, you give that example of the state and the outside organization, which located in outside extraterritorial land, and I think the whole purpose of that was to reduce some background noises, because you want to talk about if it's within the territory, you have IHRL forgiven, and you have law enforcement, and you have all that, and they are the citizens of that state and the obligations. But by choosing that option, you create a whole different set of background noises, which the main one, I think, and you refer to it a little bit, and I'm going to address it more, is the application of IHRL in that situation. So you're saying the state doesn't have control over that region, and you're looking if it's not through IHL, then how is IHRL applicable in that situation? You do need some level of jurisdiction or control or something, effective control or something that will allow you to apply IHRL. And then if you do have that kind of level of control, we might be able to start talking about occupation. So not necessarily the same level of effective control, but it will bring that background noise that you're trying to avoid. So there are a lot of background noise regardless of which option you're looking for. And for the same reason, I'm not sure that the revolving door can actually take place as effectively in extraterritorial situation. Because if it's extraterritorial situation, there's a question of whether or not there is application of IHRL. And
that's a different dissertation. The question whether or not it applies.
I agree, but I'm saying that it's a question of what I'm saying is that when you try to remove some background noises, you bring other background noises to the table. And I'm going to address that problem, hopefully. But before we go into the actual discussion, I think there is a preliminary question, which is, what is the rationale in the differences between international conflict and non-international conflict? Why one has a threshold and one and the other one doesn't have a threshold of violence? And we know that the vision of non-international conflict is not the example you're giving. When they established Common Article 3, when they established AP2, I agree, I know that when we talked about it, that these are things outside of the scope of this article, but since you're touching them, it's neither here nor there, and that's the problem. And if there is a rationale behind this threshold, that rationale might be effective also for the end of the conflict. And then there's a question of whether or not we want the state to be in charge of switching that switch on and off or not. And there's a good paper by Kretschmer that talks about the fact that sometimes the state will have an incentive to go into non-international conflict because it allows it to use power more in an easier way. But on the other hand, it is some recognition of loss of control within the country. So there are arguments both here and there, and then there are a lot of questions of whether or not whose interest would be to be in the revolving door. It's something that isn't addressed in that paper. And when we take the whole rationale behind international conflict, we need to see how is it applicable to situation of a law. And therefore we know whether or not the situation can or cannot be. I'll give you an awful example of the situation of law, or equivalent, sorry, and we actually mentioned that, which you told me this is part of a different chapter, and that's the geographical scope of international conflict. So if the IHL is not applicable in the quiet part of the state, even though it is part of the conflict, why is it different when it's quiet during that within that region? Quiet is quiet, and in international conflict, same region, same applicable law. And what I'm asking is that why aren't you referring to that? Because you have that discussion in a different chapter. And when you talk about the theories for the end of non-international conflict, you referred briefly in the paper, but if you're going into that, there are more sources, and one of them is written on a different page, but it's the PILAC paper of Naz, Bloom, and Lewis talking about ending a conflict. And they have a full section there of several theories of the end of the conflict. And they're certainly written somewhere here, but definitely you need to address them. That's the main point. And yeah, in an indefinite war project of PILAC. And then they refer, for example, to one example is when the criteria for the establishment of an international conflict, which is violence and the threshold and the organization, one of them ceases to exist, then the non-international conflict ends. Now, you refer to the violence. I think referring to the violence is the heart of what you're trying to talk about. So if you reduce the violence criteria, then your whole paper is basically void. So we don't want to do that. We're saying like, okay, let's put that aside. But if we're talking about the organization, I think it would almost be logic to say that if we need the level of organization to have an international conflict, once there is no level of organization, there is no counterpart to the conflict, and therefore there is a serious question of, is there an international conflict and against whom? And the question of not necessarily that they have lost, but they have disorganized now. And then it becomes an interesting question. Yeah. Actually, I have a reference here that check the Colombian Operational Law Manual of 2009. And I thought I'll just talk to Camilo about it. Like the rules of engagement, they're trying to find a way to go both here and there in that sense. Clearly, in that theory, the revolving door is a big problem, right? But if there are no, the second theory that they're talking about is the normal combat measures. And that means basically that we're in a loop. Now, the third one is no reasonable risk of resumption. That's a different theory, and the fourth one is state of war throwback theory, but basically they're saying what you reduced at the beginning. Now, if we talk about the standard of start and the standard of ending and all that, then all of these theories should find their place either in a short way, just refer to them, and then go forward to the rule, or you need to expand on them. But right now, it's neither here nor there. You refer a little bit even to Rochil's writing about that right after Ziv. And yeah, so they all refer to that, and they all but that part either expand it or reduce it. Now, when you're talking about the different applications of the legal regimes, so we have IHL, and IHL is usually all or nothing, although you're trying to find your loophole again, which I appreciate a lot, because I think this is what I was trying to do also in my PhD, trying to find some leeways to change things, and then had to deal with the awful question of lex lata, lex ferenda, which I considered and said lex ferenda, I don't believe it.
I know, I believe it.
All right.
I'm not trying to say it's a lex lata, obviously.
Yeah. Now, the application of IHRL, I already said it. There is some problem with saying that only IHRL will be there, and I think the best.
It's a strawman.
But the best source for that discussion, which was one of the original sources for that discussion, would be Noam Lubell's book on the use of force against non-state actors, extraterritorial use of force against non-state actors. I haven't seen it in the paper, and
Maybe it's in the geographical scope.
And then he covers the different aspects, and then yeah, if you're talking about the IHRL part, I think you need to address it because your example is extraterritorial use of force, and then the combination of between them. In the paper you talk a little bit more about the lex specialis than you talked in the presentation. In the presentation, you moved much faster to the harmonization approach. Or again, it's a question of expand or reduce. I think reduce is preferred, but you do need to address at least the source to more writing about that debate, and especially there is a quite recent article by Yuval Shani, which this I think I checked reference to both my supervisors.
What was the other one?
No. Who talks about the early, the rumors about the early deaths of lex specialis regime. I think that's the title of the paper, and it says like he talks about the harmonization, and then eventually states are talking about lex specialis, and I think it was actually last year when we did the online one, and we talked about specifically the lex specialis and harmonization and other types in the context of right to life. We had Ken Watkins saying that even Canada believes in the lex specialis model, and that lex specialis is still very strong, it's still very out there. And the problem is that with regard to targeting, which is the main thing that you're talking about, because then you go to references to the right to life. With regard to targeting, then unless you take different or weird approaches in unpublished papers, most people will say that when it comes to targeting, if IHRL is applicable, then it is IHRL is on the right to life, can't fight with that one, and generally, and it's actually, you can go to look at General Comment 36 on the right to life. If I remember, even paragraph 62 or 63 of that talks about that generally the use of force in accordance to IHL will not be arbitrary deprivation of life. Now, that's a very strong statement that kind of helps you and provides you a problem. It provides you a problem because, well, usually using force in accordance to IHL, and if IHL is still applicable, then use force in accordance to IHL, it won't be arbitrary deprivation of life. But this is where the NICE committee added the word generally. And that word generally has already been the subject of some writing, which suggests, including by the authors of the general comment, that says that generally might imply to situations where the right to life could be arbitrarily deprived, even though we are following IHL to the letter. So that could be an opening for you to use. Geographical scope of IHL we mentioned. DPH guidance section 9. Refer that in your paper a little bit. Again, you didn't refer to that in your presentation. Of course, that received a lot of criticism. But I don't have the yellow ball with me right now.
No, exactly. No, but I'm just wondering how long you're going to respond for. So I was wondering. You have plenty of questions. I've got it.
You've got it.
That was my question. Who's sharing? How long is he going to go?
Soon enough. 2-3 hours. Just 3 hours. Really? Okay. Okay. So the section 9 on the DPH received a lot of criticism during the discussions and after the discussions, and some of the people who criticized that, I think, left with some PTSD on talking about section 9. But I think the main criticism in section 9 is the differentiation between state military practice, not even state practice, and obligation that the military is obliged by. And I think Jeff Cohn, which Manu referred to him in the earlier session, added the fact that it's not only the fact that a practice doesn't mean, I mean, if you do something doesn't mean you have to do it. So there is a difference that the fact that you can doesn't mean that you have to. The fact that you can either attack someone or watch from attack one doesn't mean that you have to either this or that, and you have to find the legal framework that will allow you to do it.
Pages left?
No, not many. I'm going to reduce some of my comments and if there's something. I was worried I'm not going to have enough to say. So I wrote a few more things. So let's talk about the law and its implication. And you give the Israel-Hamas example. Have I been talking for so long?
Mm-hmm.
Okay. So I'm gonna. Okay. So you give the Israel.
Time flies when you have time.
Yeah.
Exactly.
You talk about Israel and Hamas situation and use that example more and more. And this is a problematic example to begin with. One, majority of the international community consider that it's still an occupation. And that's, although we not necessarily agree with that, this is still the prominent, the majority legal position in the international law community. And on the other hand, you even have the High Court of Justice, which you actually quote and say that this is an international conflict because it's a cross-border conflict, and that's it. When we actually had that discussion over dinner as well last night. But I find it also interesting that you can actually use a different aspect of that, and I think I'm going to finish with that.
She's sharing.
She's
I just
showing
have the
me.
yellow.
You're the threat.
Exactly.
So whenever there is a lul in Israel-Hamas conflict, and there is a resumption of conflict, suddenly there are a lot of discussion about whether or not Israel had the right to defend itself from the attack. Now, I'm not saying these are right.
You don't have out of questions if you cover it all.
But
Yeah, I think we can delete it.
but the mere fact, then you have, for example, a great paper, I think, on either Opinion Euro, such as Security, or one of them by Dapo Kande, who says that it cannot necessarily be a use ad bellum situation because it's a state versus a non-state. Also, the discussions on some of the discussions are not even going to the fact that there is an ongoing conflict, but rather whether or not you can have an Article 51 self-defense against a non-state actor.
So don't use Hamas as an example.
Don't use Israel, Hamas.
How about you
as
provide the
an
rest of your
example.
comments over email
And
Track changes.
with track changes and links to the relevant, articles?
and with
That would be
that,
amazing.
with that, voluntarily, I'm finished.
All right, so we had plenty of questions half an hour ago.
But please
Let's see who's
repeat
still
them.
sending.
It may be, don't repeat.
Do you want to
No,
react
no,
to
I
the-
want you to
that
repeat them because
also?
it would maybe clarify more things that maybe I need to.
No, I don't.
Okay.
So
I'm
please.
wondering whether she wants to react to Idil first.
Do you want to react to Ego?
No, let's hear. No, I do want to hear a question, and especially if they're a repeated one, because I think it means that there's more room to work on them. So,
Okay. Patricia had a short and quick question.
And it's not a legal question, right? So it's very, very
Refreshing.
simple. In the beginning of your presentation, I'm sorry that I missed the latter half due to that stupid phone call. But anyway, you mentioned, so there are two things, right? There's NIAC and IAC, yes? Which seems to me a very simple distinction. And I just wanted to know, is it really that simple? Okay, because for instance, what happens?
yes.
What's that?
It's a very legal question,
Yeah.
but not from a legal
No, I'm
source.
not a lawyer, you see? It's like advantage and disadvantage here, okay? So I'll give you, there's a specific case in my head that made me sort of wonder that. Take Russia and Ukraine, since we were talking about that before. There is one place in the world where Russians and Ukrainians live together, right? And that's in the Arctic, that's in Svalbard, formerly known as Spitsbergen, okay?
Ukraine is there?
It's a joint base.
What's that?
Ukraine is there?
Yeah. 50% of Barentsburg almost is Ukrainian.
Okay.
Under a Russian governor, not a governor, sorry, a consulate, okay, that has authority over Barentsburg, a settlement next to the North Pole, on an archipelago that is governed by Norway, but not Norwegian. It's under the 1920 Svalbard Treaty, okay? Meaning anybody on that archipelago has the right to live there. So they're not really international. You see, you don't need a visa to live there, okay? So if there was now an armed conflict, okay, between the Ukrainian party and the Russians in that settlement, is it national or is it international?
No, it's not because if they're individuals, if they form armed militias and they're fighting one another, it would be non-international conflict. Because
why?
If they're groups, if they're sponsored by the states, it would be an
If they're not sponsored by the states,
So
if they
it's-
just decide.
So it's kind of like you and me would fight, and each of us have an army of people. It would be a NIAC because we're non-state armed groups. The fact that we are nationals of different countries do not create this conflict. NIAC.
So that's irrespective of where we are.
Correct.
Yes.
You've got to
Okay.
look at the parties,
Yes.
not the
Okay.
geography.
Yes.
That's it.
Okay.
You
That's it.
said right at
That,
the
that was
outset.
my question. I just thought I was curious about that.
I have to say though that we have a very different definition of a simple question.
No, it's interesting.
Diletta, you still have a
Yes.
question?
Thank you for the presentation. I really loved it. I was wondering because I'm in a different way. I've also struggled a little bit with a similar topic, similar issues, because as I deal in my thesis with the war crime of denying a fair trial, when I look at non-international conflict, I have an issue, which is when non-state armed groups basically are putting together a system of civil governance activities, which kind of regime applies, like the ICRC says, oh, of course, international humanitarian law, because they want to have a say on that, let's say. But at the same time, I'm a little bit uncomfortable with that because I think that international human rights law might be more helpful, especially when we're dealing with trials. So I was wondering if this is something you have been kind of thinking about. And so my solution at the moment for this problem, which is again like a similar one but not entirely the same one, of course, is that I really go and see yeah, as you were saying, a little bit on the situation, but for me, it's like, okay, so for example, a criminal proceedings would be better, you know, regulated by international human rights law because it has more instruments to deal with that kind of situation rather than IHL. But of course, in my case, it's more of a matter of what is the trial about. So if the trial is dealing with the armed conflict, so for example, we are trying someone that has been considered, you know, like an enemy and has committed, like was a spy, for example, something like that, then I think it makes sense to have IHL regulating this trial. When it's just, you know, like murder that doesn't deal, it's not a war crime or whatever, then I think it's better to have international human rights law dealing with the trial. So I was thinking if somehow you can find something interesting for your issue in yeah, dealing with different things like thematically, and this is something that somehow you're doing because you already say, for example, interaction with civilians would be better, you know, dealt with international human rights law rather than IHL. So yeah, I know it's a bit of a stream of consciousness, but yeah, I think it would be nice to have a conversation on this because it might be interesting for us.
Are we collecting more? I think let's collect. Okay, Yali.
Yeah, apologies again that I didn't read the paper yet. And I'm afraid that I have a series of annoying questions, but I do think that they're important, and in the sense that I think that some of your responses to it were, well, this is your dissertation, and you're really in a place that you want to defend the choices, and it's legitimate, and I think that we've been there, but I do think that sometimes it's worth to take a step back and think about the project, and maybe even for the future. So my first annoying question is, why lose? Seems to me that a similar approach could be taken regarding almost any sort of armed conflict. So let's think, and it comes because I had enough with this transnational armed conflict obsession of IHL discourse, right? So we had it was reasonable when it was post 9/11, but Russia versus Ukraine was a very late wake-up call to say, wait. And so think about traditional NIAC. What's the difference? Right? We have a civil war. Sometimes we have more intensity. Sometimes we have less intensity. And it seems that your approach fits really well there, right? If we choose to adopt it, we can argue on the substance, but I don't see what's unique about a transnational armed conflict that leads to this conclusion. But even IAC, right? So think about Russia versus Ukraine. Since 2014 until now, there were periods of significant intensive hostilities. There were situations with much less. Think about Israel and Iran. What's going on there?
Syria. Depends who you ask.
Right? Syria. So all of these issues, I really want to know what will be the normative difference in all of these various situations. So I can understand the choice to focus, for example, in your dissertation on NIAC, but when you think about this issue separately, systematically, I wonder what's the solution. The second, which is also a second question, is isn't all just a matter of interpretation, right? Can we just interpret the relevant rules in a way that will lead to similar results, regardless of the position that we take about IHL or IHRL, right? Because it's very, I think, nuanced. When is it that we rely on IHRL, or when do we just call it interpretation of IHL rules in specific contexts, and so on? So, for example, and this is another scenario that you can think about, where the question is not the intensity in general, but a geographical one, right? So, for example, I think that Dave Kretschmer has a similar approach to yours when he suggested that outside the zone of active hostilities, when you target a specific person, IHRL should govern the situation, or alternatively, the interpretive guidance position of capture versus kill, right? So it's also right, broadens the conversation to the geographical zone, but also whether it's just a matter of interpreting IHL rules differently or the nuanced relationship between IHL and IHL. And the third, maybe less annoying question is that I do think, so there's a general question and then a specific example. The general one is right, what's the politics of classification and thinking about it? And I think that is it a doctrinal question or a general question about what rules should govern a specific conflict? But then the specific examples that I want to give is that there are situations in which there's, I think, informal agreement to apply specific regime in a low-intensity way that is not full-fledged application, but that actually justifies significant use of force. And it was a bit vague, and I'll give it. Think about weapon shipments to Hezbollah.
You're stealing my thunder here, but go ahead.
So, right. So if you suggested that it will limit the amount of casualties of suffering or whatever if we adopt a human rights approach to these issues, targeting Hezbollah weapon shipments will not be allowed under this. But it seems to me there is some kind of silent agreement between a non-formal one between Israel and Hezbollah that says something like this: we're not going to have a conflict right now, like a full-fledged conflict. We don't want it. And we can live with occasional targeting of weapon shipments in order not to reach a point in the power dynamic between the two entities that will change significantly the situation and will lead to a full-fledged conflict, right? So there's some kind of interaction between these actors that will be legally impossible under your solution, but maybe, right, they can live with it to some extent, and there's a nuanced application that is not dependent on the legal, right, formal classification of what's going on.
You done already?
Yeah. It was much.
Do you want more questions, or do you want to reply?
I'll reply, I think.
I'm getting stressed for you.
Okay. So again, thank you, all of you. Because it's you with them in some sort of a way. So I do see a different scenario, and it kind of answer your question and yours too, but why LOLs and not just like the geographical scope? I think there's one question of the geographical scope of IHL. And it does raise the question of, if there's a territory and in one area there's no active hostility at all, nothing happens there. Okay, I do cover it in one part of my discussion, and I mean, thinking of putting it as an article, maybe I need to draw it into it, might make sense to answer why I'm not dealing with that. And the reason is that I see those incidents as different is because there is still maybe they're different and not different so much, but they still have some sort of difference. And I'll try to make some sense of it. When I do look at a situation where there's constant fighting that are happening, and then in one region there's nothing, I think it's an easy answer doctrinally to say maybe this area, I wouldn't look at it as IHL applicable to that area. I mean, maybe that would be the case. See, has no way to answer it.
Thanks for trying.
It's like, I'm lost. Me too. Nice one. Yeah. Humor is good. Okay. So I think for the question of LOL, it would be not interesting to look at those different geographical locations. But I do think that LOLs do bring some interest to mind because they do assume that although there is this assumption of hostility between the parties to the conflict, or hostility is a weird word, but like tension between the party or the not conclusion of the conflict, anytime that there is some sort of violence raises the question, okay, what are we doing in this situation, which is different from the geographical scope of IHL. Yes. Okay. And it is different in extraterritorial NIAC than in the domestic one, because in the domestic one, obviously, sporadic acts of violence or violent protests would be regulated under IHRL because you have control over that territory and you have IHRL to your disposal. It's assumed that you need to act under law enforcement mechanism.
And then just to clarify.
Yeah.
So your suggestion is just to apply the regime that we already are doing when it's internal NIAC to extraterritorial. Right? So what's the difference in the end result of your suggestion between the two?
Because in my suggestion, I'm not assuming the extraterritorial application of IHRL. So I'm saying it without doctrinally deciding that this is what we need to do with IHRL. So I'm avoiding this question of whether or not to what scope do we apply IHRL extraterritorially. So I think I'm avoiding this massive question. And I'm giving this leeway again to do default to IHL in those situations, because the presumption is that it's still the regulatory regime to regulate the relation between the state and the non-state entity that is in that territory. And this is also the question of why I'm not really interested in laws in IAC, because I think it's less interesting. Because when two states decides not to actively interact in violence against one another, we don't have those question of sporadic acts of violence that happens, unless again you're kind of like
kill Iranian scientists from time to time.
So yeah, I have this. I said it's different for targeting. Right. I do have like I have different for targeting, and I think it's a problem for targeting, but then I'm not in that debate, I think willingly, because again, for that, I don't know if I have the greatest answer for why I'm not doing it in IAC. Maybe because states acquiesce to not retaliate against one another in those situations, and I don't want to force a regime. And maybe I can say that I'm against targeting in laws, even in IAC. I can put a caveat saying that it could also apply. And I don't want, so I it's so that I think so also interpretation of NIAC, and yeah, I think maybe this answers them both. To your question regarding when states when non-state actors start to form like legal regimes and whether or not we can see them as states, I think it's a fascinating question that I'm not answering at any point whatsoever. And I think for my advantage, it's really easy because as long as those non-state actors are not considered states, I think internationally, I don't care. Like I don't want to go into this question so much. But just for I think her name is Mara Resnick, and she writes about the fact that ISIS at some point could have been a state for the purpose of.
But in this sense, if I can jump into it, and that's my only contribution to this debate, Gaetano Rangiolowicz, who wrote in Italian, actually wrote a book on the dynamics of states, more or less, the translation is that, and he actually discussed the fact that also also non-state actors, such as non-state armed groups, may have some sort of obligations within the international community just for the fact that they are entities within the international community. So despite any sort of recognition or whatever, but I'm sure you have already read a lot about the question of the recognition of non-state armed groups or not.
But for me, I'm still, I mean, maybe it's to my deficit. I'm still more focused on what the state is doing, less to regulate the non-state actor. So I mean, maybe.
So your focus is on
exactly
where around.
Exactly. Yeah.
Okay.
I think we have Camilo and then Kaya.
Yeah.
What question?
Withdrew her question.
No, but I double checked. She had another one.
No, I didn't remember. And I was second in the row, but doesn't matter. I will be the last, and you will like it. So.
Yes.
I was speaking.
That's our last. For now, it's Camilo.
Okay.
You're going around the table.
I have 3 things to say for you. First one, regarding the extraterritorial armed conflict in the case of NIAC. Phoenix operation in 2008 by Colombian government on their Ecuador territory, but against the FARC, the former guerrilla. Yeah, and in that case was applied the ISL. In fact, the ICRC delegation in Colombia maybe did the double check for that operation, and it is a kind of the spillover, no? And for that reason, for instance, in Colombia, when they teach about the non-international armed conflict, they are emphatic to say it is not an internal conflict; it is a non-international conflict because it could be in another country like Venezuela or Ecuador. So yeah, it is interesting, and it had another consequence: international responsibility for the Colombian state from Ecuador. For instance, you can check the friendly statement in Inter-American Commission about that case, the Phoenix operation. That comment. The second commentary is about the ISPL program by Harvard. I don't know this publication. We applied that criteria and the ICRC delegation too, because as I said, and this year we have 6 non-armed conflict, but the last year we had 5. It depends on if the non-state organization complain or the requires of the level of violence or the organization, and it is common to change because it's a difficult scenario. And the third one is about the harmonization between ISL and human rights, because all time happen in Colombia. So, with the support of the ICRC, we use the ISL in the conduct of hostilities always, but other kind of situation like I don't know, mine exploitation, other activities by the non-state armed groups are regulated for human rights and internal legal system. So yeah, it is easier to apply.
This is a situation without any belligerent nexus, right?
Yeah,
it's like if someone commits a crime, robs a bank or something like that.
Yeah, in fact, our armed force have special protocols when they have to use the force, the lethal force, and another activity, the non-lethal force, like a policeman. Yeah, so it depends on the situation and the activity. Just hostilities, we use the I shall. But for instance, the control of the territory, it's human rights application. So yeah, it's interesting because, for instance, in the framework of the special jurisdiction for peace, we have to decide about the all situations, the armed conflict, maybe the last 50 years, but we have a long period to study, but not just situations in the framework of the non-international conflict are regarding with the use of force. Yeah, so we have to review when we apply I shall or we apply human rights or kind of rules. So yeah, and a good example to this harmonization is the Inter-American Court. They have a competence on the Inter-American Convention, but they have used their I shall rules to interpret special situations in Colombian context, in Guatemala, maybe Peru. So
it's just, I'm sorry to interrupt. It's just the Colombia case, and I know it's there, but I do see it as an easier case because it's for the question that I'm kind of raising, because it's obvious again that a state against its own citizens within its own territory, when it's not reached the threshold violence of NIAC, obviously will use law enforcement. So that's why I'm not really using a lot of Inter-American Court of Human Rights decision, because most of those cases, and I had this discussion with another Colombian friend, that's why I'm like, that they're irrelevant to the question that I'm raising, because they do have sufficient control or effective control, which raises the level to use IHRL as a mechanism.
Yeah, the main factor is about the non-state organization. Mm-hmm. Yeah, what is the characteristic that they can complain the level, the violence or organization, and you can apply IHL. If not, no. Yeah.
Aya? Am I the last one? Am I the last one?
No, you're not.
Okay, so can I say for the last? Because I have different type of comments, so.
Okay, fine.
If I can switch.
I want to be polite and be,
So I'm just going to pick up with first some of the comments made by Yali. I was a little perplexed as why you were looking at the transnational effect. I was left wondering why complicate your life, because exactly the same problems arise in just national, non-international conflict. Yali, I think that the situation in international is different, just factually, because you're unlikely to have the same degree of points of contact friction during a lull, both between the armed forces of the two states, but also between those armed forces and individuals. So to the extent that you have them, it's likely to be occupation. So I think just the factual questions that arise in an IAC are different.
So, for example,
I'm so glad we have dinner together as well.
If you think about Russia versus Ukraine from 2014 until now, what are the significant differences in terms of the
you've either got a situation of occupation.
Exactly.
Yeah. So it's either occupation, and then you've got a legal framework, and within occupation, you've got the moments that are related to the occupation and the moments that are the rights, as in any other occupation. And then I just think that the regulation of force between the two states is immediately IHL. So I just think it's different, factually it's different issues. Lunch, dinner. I then wanted to say, I wanted to pick up on something that Dilekta has said, and apologies, I might have missed this. And Dilekta, you've said you've got to look at it issue by issue. And I think that one issue where there is a difference, and we haven't really looked at it, is in terms of deprivation of liberty. Because we've been focusing on use of force, but definitely when we start looking at deprivation of liberty, then the fact there is a lull isn't so relevant. You've got to look at the reasons why people are deprived of their liberty. Is it in relation
The same
to
for
the conflict?
trials, yeah.
Exactly. So, So I think you've got to separate out the whole use of force thing and deprivation of liberty.
In the paper, I do put it I do talk also about arrests and detention, especially administrative detention, and ask whether or not it could happen during laws. And I'm leaning towards no, because you can only have administrative detention under the laws of occupation, which is like the solution for it. And I'm not quite sure that you can have it when there is not sufficient control. So yeah, I mean,
we've got to. I mean, I think we don't have a lot of time to look at it. I think it's more complicated than that, because what you do with the people, I mean, quite aside to the question of the procedural safeguards, but I'd say that people who had been deprived of their liberty, and we're talking NIACs, it's not administrative detention anyway, but people who had been deprived of their liberty in relation to the conflict before the law, what are we going to do with it?
Okay.
So it's a different can of worms. And then, I'm sorry, am I the only mum here?
Mom, yes.
I'm going to have a mother moment. Well, soldiers will be soldiers. I'm sorry, no. It's like, no. Soldiers will not be soldiers. States have an obligation to provide them the relevant standard operating procedures, rules of engagement that match.
I said I might get attacked on that. We'll train them.
It's not about training. It's more than that. It's the whole obligation of the states to provide them with
training and instructions and orders. And
exactly.
This is what you meant. This is what you said.
No soldiers will be soldiers.
Yeah, of course. No, I'm assuming you know.
Yeah, I didn't read the paper, so possibly it came
she
out
said
more
that.
in the paper.
Okay.
Here it was.
Yeah. All right. So much of what I wanted to ask was already asked, but I have maybe I have a imagination of a pistachio nut here. But how can you, if in a situation which you started with, when a state has no effective or no control whatsoever over the territory from which the group operates, and when it comes to the use of force, how can you completely overlook the violation of sovereignty and other relevant rules? I think you're very much influenced by Gaza and the fact that it's, the sui generis situation. And I think, and then we clarify that, your discussion and your analysis is not limited only to the use of force, but it's something like using the idea to apprehend someone across the border of your state in any other circumstances than Gaza would obviously raise the violation of territorial integrity and sovereignty issue.
But do I have to? I mean, I understand what you're saying. It also happens, let's say, in Yemen, in Iraq, and then you have those solutions of they were invited and this and that.
And that brings me to my second question. That's something I think you don't have to necessarily discuss it, but you need a footnote, like as a protective shield. No pun intended. Because the position or the approach of the third state in which the group from which territory the group is operating is crucial here, right? Whether it's cooperative or unwilling or unable, like.
It's a footnote for a discussion that has been going in literature, and she just has to say that acknowledge the discussion, says she's following that line of thought.
Right, but I know you're writing a monograph, and this is, clearly I don't know the rest of your work, but you might, if you want to publish, and I'm assuming you will, you might want to reflect at this stage already if you're writing a case study of Israel-Gaza situation, or you want something more general, because if you do, there is a bunch of issues you have to cover, like what we were just mentioning here, and then it cannot only be, it needs to be more than a footnote.
Not in this article.
Not in the article, I'm talking about the monograph.
But we're talking about the article. The purpose is to get that article into publish, and if she's going to expand on the definition of an act, the situation of that, if she's going to expand on each and every question, it's going to be the monograph.
Because we had a conversation.
But why is it necessary to discuss Yusuf Bellum
when
the topic is Muslim Bellum? You can say there are also usability questions here, but
that's what I'm saying. You don't need, she doesn't need to discuss it, but it needs to be, you know, excluded. A footnote, excluded caveat. Like it's something that I've been through this recently, and you'd be surprised how ridiculously stupid questions you get from, you know, editors. Editors of the book. Okay, and they ask you questions like, obviously, that's not even within the scope of, you know, whatever you're trying to publish.
Yeah, no, I
yeah. And Kaya?
Yeah, thank you.
I actually want to wrap up this discussion.
What? We're really curious as to this.
Yeah, I want to wrap up this with a different comment of the different nature, but it actually points to the other questions. Actually, I really like your energy and keep it up, because for presenting issues, this is something that keeps people at 4 or 5 in the evening awake. And I really like the presentation, the fact that there was, and I know I read somewhere that people are divided into groups, those who hate presentations to follow because they cannot focus on listening and looking, but in that case they can just look in different direction. But then there are other people, and I belong to that group, that I cannot really focus only on listening. So then presentation is of great help. And coming to the presentation, and I think that workshop is also directed and not only, you know, the substantive questions, but also to grow up as professional, and some of your questions pointed to that maybe for the presentation of the topic, it's always great to frame the scenario pretty precisely. So then we don't have those many questions, what are we talking about? And it allows to follow with the specific questions. So, for example, the breakup into how the situation would vary if it was IHL or human rights, that's somehow, for me at least, as a listener and probably reader, easier to follow and understand. And one more note that I know it was not on purpose, but also for the sake of understanding, because you tend to firstly speak about something and then show it on the slide. And this is actually the reverse direction. It's hard to follow. Okay. So, but I wanted to say that in general, it was great, and I hope that you will get it published, and I will read it with pleasure. Thank you.
Housekeeping issues, dinner, transport. I have no idea.
So the recording. So